2, 1.
Okay, this is the 12/16/24. This is a meeting of the Templeton, Mass Conservation Commission on Town Hall, 160 Patriots Road, East Templeton, Mass, so 1438, in the conference room. Okay, number one is a review of meeting minutes from 11/18/24. Has everybody present read the meetings?
Yes.
Yes. Okay. Make a motion, we accept.
I'll make a motion to accept the minutes.
I will second it.
Hearing a motion to accept the minutes that has been seconded, we need to take a roll call vote. How do you vote on accepting the minutes, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
Yes.
You? 6:31.
Okay.
Mr. Andrews, will you please read number 2?
Now we'll go to number 2, RDA for Old Athol Road for the water plant to remove trees in the buffer zone of a wetland to access an underground public water main. Request is to determine whether the activity is subject to WPA and its regulations.
Today with us, we have Scott Schwinger, who is the water superintendent from Templeton Light and Water, to open the, can I get a motion to open the public hearing? Mr. Andrews makes a motion. Do I have a second?
I second it.
On a motion to open the public hearing, how do you vote, Amanda?
Aye.
Dave?
Yes.
George?
Yes.
Joanne?
Yes.
Good. And also I have to read the legal notice. Templeton Conservation Commission, Old Athol Road, request for determination of applicability. Notice is hereby given in accordance with the Massachusetts General Law, Chapter 131, Section 40, the Wetlands Protection Act, that a public hearing will be held on a request for determination of applicability filed by Scott Schwinger, Water Superintendent for Templeton Municipal Light and Water Plant. Project location is Old Athol Road, Templeton. Description of the project is the removal of trees in the buffer zone of a wetland to access an underground public water main. Request is to determine whether the work depicted is subject to the Wetlands Protection Act and its regulations. The hearing will be held on December 16th, 2024 at 6:30 p.m. at Templeton Town Hall. Any person wishing to be heard concerning the above application should appear at the time and place indicated above. The request for determination of applicability is available for public review at the Development Services Office, Room 3, 160 Patriots Road, during regular office hours. The RDA is also available upon request from J. Case at templetonma.gov, George Andrews Chair, Templeton Conservation Commission. So to start, since Scott is here, would you like to, for the record, for anybody that is not the commission, state what the request is? We'll go from there.
The request is to cut down 6 trees. Because they're growing over a cross-country water main.
And you had a water main break there in the past.
We did.
And he had to get in there with an emergency cert. And we went to the site and the commission actually advised you to submit the RDA so that you had a permanent permit on file instead of operating under emergency activity.
Right. Because it was so much work to be done.
Right.
We just couldn't get it all done in that emergency time frame.
When is the work going to be done?
I haven't scheduled any work yet because I wanted to get this part done first.
Okay.
So once this was finished, then I was gonna call up a tree company and pretty much gonna schedule it in whenever we could. There's no real emergency, but I'd like to get it done sooner rather than later.
Yeah, it'd probably be best to do it when the ground's frozen. It's pretty muddy out there.
Yeah, we can do that. We can make that a priority if you want.
And the other question, you're not going to be stumping though, right?
No.
No. Okay, good.
I would like to grind some of the stumps where they stick out of the ground a little bit, but we won't be pulling any out of the ground unless there's a water main break.
The application says any grindings of stump will be to a depth not to exceed 3 inches.
Right.
Upon Scott's submission to us, he also submitted to Mass DEP, and they came back with some comments that were sent to you all and to him. Mainly, they were saying about how the map provided didn't show the commission of the exact location of the activity and wanted a little bit more detail. Since their comments, Scott provided an additional map showing where the trail was, and he provided a picture of the trees with the X's on it. I also did reply to Mass DEP and tell them that the commission was very familiar with the site, and they had all been out there, and they had all requested the RDA. Just so we're all on the same page.
I believe this falls under 10.02.
2B?
2B. Yeah, minor
Well,
activity.
that's what he's filing under, minor exceptions.
Yeah, because it's a underground utility, water specifically, within an existing prior road, discontinued road, which the spirit of this is roadways, within the buffer zone. So
The alternative is if, God forbid, that location were to experience another water main break, and Scott and his team has to get in there to fix it for public safety, he's going to follow under the emergency exemption for utility maintenance.
Right.
So instead of being reactive for a situation, he's trying to be proactive and have the permit there. So instead of actually dealing with the trees during an emergency, you can actually just deal with the water main and not.
Yeah, it's better to get the trees out of the way first.
And then to, keep it maintained, say with, weed whacker, brush cutters
Yep.
from here on out, so it doesn't get overgrown like it has.
yeah, I'll make a motion for a negative determination.
I'll
With
second,
conditions.
with conditions, yes. I'll second.
Okay, we have a motion for a negative determination by Amanda. Negative determination with conditions by Amanda and seconded by George. Any further discussion? Hearing none, we need to take a roll call vote on a negative determination. How do you vote, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
And Joanne?
Yes.
All right, Scott, I will get that paperwork to you within the week.
That'd be great.
Actually, let me take that back. I need to get their signatures on Zoom. So whenever I get that, I will get it to you.
Sure.
I can be in on Thursday.
Okay.
Great.
So I'll get these two here and I'll have to get there too.
All right. Great.
And I'll
Thank
reach
you
out
all.
to you. You're very welcome.
Appreciate your
Sure.
time.
Dave, I will take back the application that's in the middle. Yep. Yep. Thank you. So I'll need signatures in a minute. Legal notice. Mr. Andrews, would you please
We're now
read
on-
number 3?
We're on number 3.
Yes, sir.
NOI, file number pending, continued. Patriots Road 2-07-20.8 for the construction of a driveway crossing the wetlands and the installation of a septic system within the buffer zone.
Can I get a motion to reopen the public hearing?
So moved.
Can I get a second?
I'll second it.
We have to take a roll call vote to reopen the public hearing. How do you vote? Amanda?
Aye.
Dave?
Aye.
George?
Aye.
And Joanne?
Yes.
We are reopened. So there's no representation present We don't have a file number assigned yet, and we also do not have a site walk, so there is no further information to add on the topic.
I make a motion, we continue it.
Can I get a second?
I'll second.
On a motion to continue this topic to next month's public meeting, how do you vote, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
Yes,
Very good. So that one is continued.
Okay.
Mr. Andrews, could you please?
Okay,
read
we're
number
ready for
4?
number 4. NOI 304-0394, continued, South Road, 311 39.5 for the construction of a driveway to service a proposed new single-family home by crossing a wetland and replicating it.
Can I get a motion to reopen the public hearing?
I'll make a
So
motion.
moved.
to Reopen.
Can I get a
Seconded.
Oh, there we go. I got it. Motion made to reopen by Dave and seconded by Amanda. How do you vote to reopen, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
yes,
We are reopened at 6:41. We have Greg Roy of Dillison Roy with us. He has provided a revised notice of intent site plan in response to Mass DEP comments. What order do you want to do this in, Greg? Do you want me to read the comments into record and then do you want to respond? Do you want to just go right to it? What do you want to do?
I am at your service. However you folks would like to do it, I'm happy to do it.
Well,
I'm happy to oblige.
I think I'll read the comments just so that everybody's on the same page of what he's responding to.
Okay.
Sounds great.
All right, so this is the project on South Road with the driveway crossing to build a single family home. And the site walk occurred and recommendations were made to adjust the driveway location to where the existing cart path is. So Mass DEP provided a file number and said the following. Based on aerial imagery, it appears there may be a stream associated with the bordering vegetated wetland proposed to be crossed. Additional information should be submitted. If a stream carrying culvert, the culvert must be designed to fully meet stream crossing standards. The commission should include conditions that require at least a 2-year monitoring period and steps to ensure the proposed replication area will meet or exceed the performance standards outlined in 310 CMR 10.55 4B 1 through 7. Conditions for the replication area, should it fail to meet the standards, may include the commission requiring additional measures that ensure the function and value of the replication area prior to issuance of a certificate of compliance. The commission may want to include a condition that the replication area must achieve 75% survival of all planted strata to be considered in compliance. Those were Mass DEP's comments.
Yep.
And Mr. Roy did provide us a response to all of that. Do you want to kind of touch base on all of those?
Sure.
That would be great.
Thank you very much.
Yep.
Greg Roy with Dillison Roy this evening. I appreciate your time. So as Jessica said, we did issue revised plans shortly after receiving the DEP comments. And I did issue a letter that's dated November 27th that summarizes those. I will summarize my responses to the DB comments, but I also wanted to point out that my letter also included some responses to some of the things the things that we heard at the opening meeting. I think that was 2 months ago now, from some of the abutters and also some of the comments we got from the commission. So I'll kind of go through and summarize those.
Go through them. You
I'll
don't have to skim. We should.
No, I won't skim, but I wanted to just preface with that.
Yep.
I'll talk about the DEP comments first, though, because I think those are what Jessica read. So that's in my letter. That's on the second page, number 6 and
Yep.
7. Number 6 pertained to the presence of a stream. We didn't really observe any stream bank per se. I think that certainly nothing that's contiguous across the frontage. I think I was out there with 3 of you at the site walk. You can either confirm or deny what I'm saying, but I think if you look in a wet period of time after snow melt, you might see a flow running through there, but we didn't really see any defined bank. It's also not shown on a USGS map in any fashion as a blue line, an intermittent or a perennial stream. So we really didn't see that this rose to the level of stream crossing standards. However, we did provide, as we mentioned in the opening hearing, as we presented in the at the site walk, we are proposing culverts. And actually, as a result of the site walk, we added a second set of culverts. So we're sort of doubling up, if you will, to make sure that we maintain the hydraulic capacity across that area and make sure we catch all the local low points. It's really an area where it's, I don't want to call it pit and mound, but
It's low.
it's low,
Yeah.
certainly wetland, but there's a few different areas where it channelizes during wet periods of time for sure. And, but I didn't see that there was really any bank per se, if you will. So that's our response to the first comment.
So they're saying based off of aerial imagery.
Yeah, I get it, but we've now been on the site.
Yeah.
So, I get DEP doesn't do a
All
site
their
walk,
maps
but
don't classify it as a stream. They're all classified.
there's no lineal feature on GIS.
Yeah.
There's no really the definitions of stream bank in the Massachusetts Wetlands Protection Act really relies on USGS. And there's no blue line on a USGS map in this area. So it just doesn't have that characteristic. Be that as it may, there are still situations where if you have a defined bank, you would still need to meet stream crossing standards. We just didn't see it out there. I don't see that it's defined enough where you have that.
When you were out there, you saw crushed stone.
Yeah.
So you're not gonna see any type of bank.
Yeah, in that area, but even then, we'd look upstream and downstream. We just didn't see a real defined stream running through there. I mean, correct me if I'm wrong, if you think I'm.
Was there a flow of water?
When I
No.
saw it before the crushed stone, there was moving water. Not a lot.
Yeah,
And it wasn't in thawing times. It was
Right.
in, I believe it was midsummer.
yeah.
It was, yeah.
And I think you were there too.
Yeah.
And we saw water coming down. There was somebody working on the other side and filled this trench with crushed stone, so
Yeah,
we could
and we
get on
talked
the other
about,
side.
yeah, and we talked about that on the site, right?
So, I didn't see a river,
Right. I mean,
but I
that's
did see moving water.
certainly the gradient, there's a gradient across the site. If you walk down the driveway from the road, your back's to the road, it's high on the left and it flows from left to right across the site.
Yep.
I just didn't see, I see this as a more wide wetland system that has some areas that at points as it's flowing from left to right, might get a little bit narrower in places, but you have a broad wetland. You don't really have a defined stream, if you will, that you'd really see with a USGS. Yeah.
I was also on that site walk and I didn't see any defined stream channels out there. If anything, they were more like, a swale type to me. And I agree that it is kind of just a wide open, wet area. And if you get heavy rain, it is gonna channel a little bit through there. So I'm in agreement with the engineer.
Thank you. So that's really our stance on that. If there was a defined bank, if the channelization had taken on the characteristics of and created something that was defined as bank, which we just don't see there, I think this would be a different discussion. So
What type of culverts are proposed? The
we're
18?
we're
18?
proposing four 12-inch corrugated plastic pipes.
4
Right.
12-inch?
Yeah. So in each, two locations, and in each location, we're proposing 2 12s. And really, that's just in this type of situation, we like to have redundancy.
Would a box culvert?
We just don't think
there-
it rises to the level of
Yeah.
a box culvert in this case.
Well, it's just like so low down there. You can almost create a bridge.
Yeah, but it's so wide that we thought that,
Be a pretty wide
yeah,
bridge. Okay.
The inside of that corrugated pipe, that's smooth. or
smooth
corrugated?
line corrugated pipe.
Smooth.
Yes. So the outside's corrugated, but the
Yep.
inside's smooth line. That's correct.
Yep.
Yeah. Thank you. Yeah. So that's that question. The answer to the second DEP comment relative to condition, should you approve it, conditions requiring monitoring and things, those are actually already baked into our plan. So on sheet 2 of our plan, on our replication notes, you'll see that we put this together based on the state's replication guidelines, and that already, it already says, it has the language in there that, C8, for example, says, after subsequent growing seasons, if a greater than 2-year monitoring program is required, where do I have the 2-year monitoring? We have this, note 10 is plants shall be replaced as necessary to ensure a 75% survival rate. So all that to say is, we've already included those and we don't have any objection to it issuing any conditions relative to that, as DEP suggested. And then one of the reasons why we're proposing in excess, I think we're almost at a 2-to-1 replication ratio. The reason for that is so that we ensure that if we only get 75%, we're still going to be north of 1-to-1 replication to meet the standard. So that's one of the reasons why we don't just do a 1-to-1 replication, we do more, because, sometimes on the fringes.
You're creating yourself like a buffer in case something
Correct.
doesn't grow.
Yeah, and sometimes on the fringes of these things, you just have a hard time getting the vegetation cover that you need to do that replication. But we have no objection to those conditions.
Even though they're submitted in your plans, you wouldn't be opposed to us specifically spelling them out
Nope.
in an order and conditions if the commission were to approve.
Not at all. No problem. And then I had 5 comments before this. I'd like to just go through
Please.
just for the record. And the first 4 are what I believe to be questions or comments of butters at the first meeting. And I'll just go through my letter and read them. A butter comment 1, the FAA VOR aerial easement. I'm not sure what all that stuff means, but
Plain talk.
and clear zones should be reviewed to ensure that the proposed house will intercept, will not, what I meant to say, will not intercept the various criteria. We took a look at they handed me a document, this particular butter, and we took a look at that. The tower is about 50 feet vertically above, the base of that tower is about 50 feet vertically above where the proposed house is. And all of those clear zones are defined as 1 degree or 1.5 degree, 2 degrees from the base of that tower up from the base of the tower. So we're nowhere near,
Well below.
we're well below any of
So
those
that-
planes.
That's the footprint of the tower.
Yeah.
Above the ridge of the house.
Correct. Yeah. So the house won't even get to the top of the house won't get to the elevation of the base of the tower. And all of those clear zones are sort of slope up from that point out horizontally, if you will. So we did check that. We don't see any issues with that.
I'm sure your clients don't want an airplane
We-
near the top of their house.
No, for sure.
Or being radiated.
Right,
Right.
yeah.
Right. That's right. In a past life, I worked for Raytheon on radar towers, and we got into some of that stuff. You don't want any radiation from a
Yeah.
radar tower, for sure.
So you said it's 50 feet lower than the elevation
At
at the
least,
base
at
of the
least,
tower.
yeah, at least.
That's the
So
top of the house, so that's like.
That's that's like the elevations of where the house is going existing and where the tower is.
Base of the
at
tower
least
is.
50 feet, and you can't build a house that's 50 feet in
Okay.
Templeton.
And you wrote 80 feet.
So it could be 80, did I say? Thank you.
You're
It's
saying,
80.
you're saying 50, but you wrote 80.
80 is correct then.
Okay,
Yeah, I'm going off of memory. I thought it was 50.
Okay. All right.
Apologize. I should just read what.
read
Read
what
the
you wrote,
script.
Greg.
Yeah. Number 2, there was an assertion that a right-of-way exists over the subject property for the benefit of the FAA site. We reviewed the deeds of record again. I talked with my surveyors again. We did a complete survey of the property. We do not see anything in the chain of title relative to that. Number 3, there was a butter question about how many bedrooms the septic will accommodate. I think I said that night, but just to put it in record, we are proposing a 4-bedroom septic system. I think that has now been,
I think, yeah,
Reviewed
they
and
asked that
approved.
because the plans looked like the septic system was for a larger capacity house.
no, just a 4-bedroom
I
system.
think it was because the perk test
The perk tests are really slow.
was super slow, so they needed a cumbersome system.
Right, big system. Some of these things resemble helicopter landing pads when you're done with them, but
That's just a normal system or a Presby?
great question. I didn't bring the septic plan. Yeah, it's normal. It's just a trench system. Yeah, stone and trench. So not even an IA system. And then a question, how will offsite properties be protected from runoff from the site? We talked a little bit about this just now, but so the wetland system runs parallel to the road, if you will. I think the folks that were on site can attest that the abutting house is quite high, quite a bit higher. We've now doubled up the amount of culverts that we're proposing here. So we're really intending to just maintain the flow across here. We're not proposing any changes except for within the, say, 20 feet or so of disturbance area between the wetlands for the driveway. We're not proposing any downstream changes to the grading, no up gradient changes to the grading. So we really don't expect any changes to the hydraulic capacity. Even if you were to look at the presence of the driveway and the land covers, it's really not significant enough to cause any noticeable metrics to runoff on the site. And while the wetland system does go off onto the abutting property, I note that it does then enter back on to the subject property. So we have, there's really not any issues that we can see relative to downgrading and flooding.
After your second set of culverts,
Yes.
something like, I think it was like 25 feet, 30 feet. The elevation started to go
That's correct. Yeah.
up quite a bit.
Yeah, that's correct.
So you're getting away from it.
That's correct. Yeah. And we put the second set of pipe in there. It really is related to the fifth and final thing, which is when we were in the field, it seemed to make sense that we shift the location of the driveway. I think that you folks were there, to better align with the location of where the existing path goes through, to align with where that riprap was placed.
Right.
And when we were there, we noticed that there was a couple of spots where we thought the culverts, might be helpful to pick up sort of local low areas, if you will, across the driveway. So we did revise the alignment of the driveway. We survey located the existing cart path, and we aligned the driveway, with those with that path. And so now we don't have any tree removal proposed. I think you might recall that we were proposing to remove a couple of those mature trees,
Yep.
which really did not make any sense when we went out and walked it. So we've been able to completely eliminate that. So really, there's no tree removal until you get outside the wetlands on the other side of the crossing, and then we'll have we walked, at least one member. Dave, was that you? I think we walked out. Yeah. So there'll certainly be some tree clearing when you get past the wetlands, but in the wetlands themselves, there's no tree clearing proposed.
It turns out much better.
I think so. Yeah. It was one of those situations
Yeah,
where it,
rather than pull the trees out over here, it's better to do what we did there.
absolutely. It made all the sense in the
For
world.
the neighbor.
Thank you. So you're gonna use the existing cart path?
Yeah.
That's correct.
Thank you.
Well, that just only makes sense.
Mhm.
Why disturb more earth?
Oh, I agree.
when
I agree.
It's not really necessary.
And that's all I had. Happy to take any other questions that you have.
I think we should see if the abutter has any questions since you're here.
I mean, I basically answered.
Did
what
he
was-
address your concerns?
Basically, yeah. I mean, my concern was, with the removal of the trees on where it was. Basically, that's pretty wet right there. And the only thing I kind of disagree with is the stream thing, because I've been there 5 years, and other than this year, I see, and I'm not saying it's a Grand Canyon going through there, believe me.
Yeah.
But there definitely is moving water back there. There's no doubt.
No doubt there's moving water. I just don't think that it rises to the level of a bank as defined by the Wetlands Protection Act. It's really a semantics thing. I don't disagree with it. There's moving water through there, but there's a gradient. It's high over here and it's low here. So you're going to get moving water. I just don't think it has a defined bank or channel, if you will.
Well,
And it
because of
may be
that,
a-
you added more culverts.
Yeah, and I think there may be certain places, like you may have a certain chunk of it. I just don't think if you looked that you'd find a thread line going all the way up through like you would on a classic stream.
I don't think I saw anything beyond that. It
No,
was just right at that point.
yeah,
Where you could see some running water, but that was.
Yeah.
I mean, it's a little bit different now. We've been
We're in
very low.
critical
Yeah.
drought.
Absolutely.
And so, and having two
Hmm.
12-inch pipes, so you're probably like this by this. But you're gonna have four of
We're gonna have
those.
4 of them now.
That's a lot of escape for water. Running 24/7,
There should be no backup.
right?
No, I mean,
That's my main concern.
Yeah, no,
I mean, I'm
absolutely.
not trying to prevent somebody from building a house. I just,
Yeah.
my concern is I have no water in my basement now and I
Yeah.
want to keep it that way.
yeah,
That's my concern, to be totally
I
honest.
get it. I totally get it. I really, I understand I'm the applicant's engineer, but I really don't see, based on elevations and things, how that could really be the case in this case.
So hypothetically, if I do start getting water in my basement, do I have some kind of recourse on this or how does that work?
Yeah, I mean, yeah, you can always, I mean, I don't know. The board might, you always have recourse. It might be a civil matter, but I mean, you always have recourse if you think that you were wronged by, an abutter, but, I don't want to put words in the commission's mouth, but it's really not a matter of the commission, to be quite honest with you. It's, drainage is one of those things that's actually by state statute, in the purview of the Board of Health, believe it or not. But I'm not certain how every town sort of implements that, themselves, but I mean, you could feel free to come back to this board and ask if there was an issue or take it up directly with the abutter. That's typically how it would be done.
But your intent is not to design a driveway for your applicants that
No.
would wash out.
No,
So, he has to try to design things.
no.
No, I understand it,
Them
and I
too.
get it.
Yeah, yeah,
But he went back and,
Yep.
he's given. I get it. I
Yep.
get that.
Yeah.
Yep.
I just, like I said, that's just my main concern.
Yep.
That's
I
all.
understand. Yeah, I understand that concern. And that's why we do the, design the plan.
And that was one of the reasons we said, you said, oh, the driveway, it's already there. There's no sense of going through, taking all the trees down, all that
Yep.
stuff.
So hopefully it'll keep.
And that'll
all
keep
that
the
tree.
water away from that area.
And with an open driveway like that, it's most likely going to regrow heavier on both sides
Mhm,
of that, because a lot of sunlight's gonna get in there.
mhm.
Vegetation grows,
Yeah.
eats up more water.
Yeah, more vegetation that grows, the root systems will absorb more water and it should be less saturated there.
Okay.
Amanda and Joanne on Zoom. Questions, comments, concerns, general statements. Amanda with the
You
thumbs up.
okay, Amanda? Okay.
No, I'm ready to make a motion. I'm just waiting for everybody to finish the conversation.
Appreciate that.
I think it's a good plan. I think, it's been amended, changed for, to what we saw in the field. So, yeah, I'm ready to make a motion I'll make the motion to issue an order of conditions.
You can second this.
Did anybody second it? Yeah, I'll second it if nobody did.
Nobody
Thank
made
you.
a second yet.
I'll second it.
We're waiting for you.
I have a motion by Joanne to issue an order of conditions, seconded by Amanda. Any further discussion? Hearing none, we need to take a roll call vote to issue the order of conditions. How do you vote, Amanda?
Aye.
Dave, George,
Aye.
and Joanne?
Yes,
Very good. Okay, so, Dave and George, let me pass.
That was number 5. You ready for number 5?
No, I'm not. Hold on.
Yes. Okay.
And also Greg,
Yes.
one of the things I have to fill out on the order of conditions is the proposed alteration and the permitted alteration, and you were saying how when the driveway moved to align with the cart path, that there was less disturbance.
Yep.
Did your overall numbers change, or did it only change in the fact that you're not taking down trees?
Nope, the overall numbers changed. And if you go by the plan,
Well, because usually it's in the NOI packet.
Yeah.
I didn't get a revised
I
NOI.
can update that.
No,
I can do that if you
could
want.
you?
Yep.
Please? Okay,
Certainly can.
okay.
Yep, but the numbers will just be updated based on the updated plan numbers. So you have them, but I will.
They're on the,
Yep. Yeah, they're on the.
Can you just read them out loud for her so she can
Yeah,
write
that
them
would
down?
be great.
Certainly can.
Let's,
The proposed permanent wetland disturbance or filling.
Yep.
Is 3,547 square feet.
Yeah.
Okay. The total wetland disturbance, so it includes the sort of 2 feet on either side where the silt fence will be
Yep.
put, if you will. If you include that, the total disturbance, temporary and proposed, is 3,953 square feet.
and do you have the square feet of the replication area too?
7,400 square feet.
Oh, so you like you said, you almost doubled it.
Right.
Yeah.
Right.
Okay.
So we
And then there's always a line that's buffer zone and it's 0 because you're in it, right?
correct.
Okay.
Yeah, that's correct.
Repeating to you what I said to everybody, which is I have to get their 2 signatures, so I won't have the order of conditions ready immediately.
Fine. Fair enough.
But I will work on that. Oh, are these mine too?
You still want the form for the file?
Yeah. Could you,
No problem.
please? Yeah,
We're,
just a PDF copy and I'll add it to the file. Just
we're guilty
update
as probably all engineers about not wanting to do any more paperwork than we have to.
Yeah,
Like,
no.
we like drawing plans, so I
Yeah.
apologize for that.
it. Those plans were accepted, so those are the plans we'll go
Yeah.
by.
No, and we'll just
but
update the formwork for
Paper,
those.
yes,
Yeah,
that would be great. Thank you
I
so much.
apologize for that.
Okay. That was number 4. Mr. Andrews, number 5. Read,
Number
please.
5.
Thank y'all.
Okay. You want this?
Is that for the other one? Yeah.
Okay, number 5, notice of intent, number 304-0395 continued. 50 Shore Drive for the removal of an existing deck and construction of an addition to the single-family home within the buffer zone of a wetland known as Partridgeville Pond. This is a continued.
Okay, can I get a motion to reopen the public hearing, please?
I'll make a motion to reopen.
Can I get a second, please?
Second,
Who was that? Joanne? Thank you,
yes.
Joanne. On a motion to reopen, how do you vote? Amanda,
Aye.
Dave,
I,
George,
Aye.
and Joanne?
Yes,
Thank you so much. We are reopened. Again, we have Greg Roy of Dillison Roy here. He has provided the commission with a revised notice of intent site plan in response to Mass DEP comments.
Do you want me to
the same
summarize?
thing? Okay.
Yeah, go
All
ahead.
right, so I'm gonna read Mass DEP's comments for the record, and then Greg's gonna go through and respond to them. Based on the Q3 flood zone layers from paper firms, at least half of the site appears to be in bordering land subject to flooding. The NOI is marked as buffer zone only, and the site plan does not provide a BLSF delineation line. What is the base flood elevation, and does it coincide with the elevations on this parcel? Additional documentation should be submitted to Mass DEP and the commission. The applicant should quantify impacts to the BLSF, revise the NOI, and provide an analysis that demonstrates compliance with 10.574. The performance standards require incremental compensatory flood storage unless the applicant submits an analysis that demonstrates there will be no increase in the horizontal extent and level of floodwaters during peak flow. A cut and fill chart should be provided, should include incremental compensatory flood storage be required. Sorry, I tripped over that, but
That's okay.
okay.
So again, for the record, Greg Roy with Dillison Roy. I appreciate your time this evening. Thank you for reading those, Jessica.
Yeah, sorry about that.
So both of the comments essentially relate to the presence or lack thereof. They assert that there's presence of BLSF on the site. Think I submitted,
I did not get a new NOI, but again,
you didn't
same,
get a new, but I submitted a letter dated December 4th. Do you
Yes.
folks have that?
they have that, yeah.
Does it have one of these behind it?
I can't see what you're holding up.
No,
No,
it
it just
doesn't have
has
that.
your
Okay.
updated plans.
Can I hand this to you?
Yes.
because we have a situation here where we have a graphical snafu here. Okay, so the, and I realize, I apologize for the folks at home, for the folks on Zoom that you can't see this. You're gonna have to trust the, the folks here in the room. The green hatched on that plan, so BLSF is an abbreviation for bordering land subject to flooding. It's defined by the Massachusetts Wetlands Protection Act as coincident with the 100-year floodplain as shown on the FEMA flood insurance rate maps for whatever community you're working in this case, Templeton. What the 100-year flood zone can come in two different criterias. One is it can have an elevation associated with it. It can be part of what's known as a detailed study area on larger rivers, such as the Millers River or things like this, where FEMA in years past has done a detailed survey of the area, and they've run flood analysis, and they've determined on those maps what the elevation of the 100-year flood zone is. In that case, it makes the surveyor's job really easy because we tie into the same datum that they tied into on the flood insurance rate map, and we just assign the elevation around the site. The other option, and unfortunately that's what we have in this site, is that it's an unelevated flood zone. It's a sort of a general zone A, as we call it, area that does not have a 100-year floodplain elevation associated with it. And that is in fact what we have on Partridgeville Pond. Mm-hmm. So in those cases, we have what's known as a graphical representation of the 100-year flood elevation. What I've printed out for you gentlemen here, is a picture of the Massachusetts GIS data layers that has the green area superimposed over the pond and the surrounding areas. And what I want you to see is, and this happens from time to time, the polygon, if you will, is not correct. And you can see that it's not correct because it doesn't follow the outline of the pond. If you can see that, there's no way that you could have the polygon there is shifted offset from the pond. If you can kind of see, you see what I'm saying?
This pond is also controlled with a dam and a spillway, so it doesn't really matter.
Yeah, exactly. So now I'm going to get to that in a second. So that polygon there, and that's what DEP is using. They're turning on the data layer, and they're saying that on the subject site, it looks like it's halfway up into the property. But there's no way that it can be because the whole thing is translated. It's just one of those GIS things where
Looks like it should be shown.
exactly. There's no way that it could be like it's shown on that plan because otherwise, the elevations just don't make any sense. So what we have done is to take a look at this from an engineering standpoint, based on the fact that this is a pond that has an outlet control structure. We believe that a reasonable estimation based on the elevations that we're showing on our plan, which by the way are tied into a published datum. It's based on NGVD, what we know as National Geodetic Vertical Datum of 1988. We believe that the 1094 contour all the way around the pond probably represents a pretty good approximation of what that image should be if you shifted it.
Essentially the shoreline.
Essentially, yeah, actually a foot above the shoreline,
Foot above the shoreline.
vertically above the shoreline,
Okay.
more like 5 or so, or 10 feet, depending on where you are around the pond horizontally. However, because it's not elevated, what we've done in the past is we've taken a conservative line and we've bumped the elevation up a foot.
So 2 feet.
So 2 feet above where the water is today. That elevation is 1,095. We've shown that on the plan where that is on our site. So we're willing to kind of take a conservative look at this. And my point is the proposed work is still about 3 or 4 vertical feet above that elevation. So there's really no proposed work within the bordering land subject to flooding if you kind of look at it and have to kind of read between the lines a little bit. And I realize this is hard for the folks at home to see, but
Greg, what's the date of your revised plan? So I can make sure I gave them the right
yeah,
one.
December 4th.
Okay, I did.
And so it's one of those situations, and we run into this from time to time, where when you turn on the data layers on GIS, I'm sure many of you may have seen this, where if you're looking at parcel lines and things, GIS maps don't always play nice with those kind of things. They're not the most accurate things, and we're running into that
I'd
situation
like
here.
to say that maps are flat, but the world is round.
Right, exactly. So that's how we went ahead and defined the bordering land subject to flooding on this map. We essentially took what we believe is a conservative view of where that would be from an elevation standpoint, about 2 feet or so above where the water surface of the pond is, which we do not believe we would ever get to that point. And we're essentially defining the limit of the bordering land subject to flooding on the site at that elevation and documenting to you on the plan that all of our proposed work, indeed, the silt fence is still 20 to 30 feet upgrading of where that point is. So we're not proposing any work within that area.
So no work within the bordering land subject to flooding, but
That's
still
correct.
in the buffer zone.
That's correct. Still in the buffer zone, but no. So if DEP's comment would have been, if we were proposing work within the bordering land subject flooding, that in itself is is another resource area. And we would have a whole set of performance standards, compensatory flood storage that we would have had to show you as DEP suggested. But since we're not doing any proposed work or any proposed floodplain filling within that area, there's really no need to do any of that because we're not proposing any filling or any work.
All right, so we got map error and no work in filling, no work or filling in bordering land subject to flooding, but still in buffer zone.
Correct.
If there's no other conversation, I'll make a motion.
Just absorbing.
Right, I'll make a motion to accept the amended NOI and issue an order of conditions approved, subject to the standard conditions.
Second,
Discussion, I'd like an updated NOI. Same, right? Or
There'd be
did
nothing-
anything change
No,
with the last one?
nope.
Okay.
Nothing changed, he just
No number.
molded a elevation line.
You know, there was an assertion that there was another resource area.
Back to my request, that's
No,
fine.
that's okay.
Any further discussion, George or Dave? Okay,
Nope.
so Amanda has a motion to accept the submitted plans and issue an order of conditions, seconded by Joanne. How do you vote, Amanda?
Yes.
Dave?
Yes.
George?
Yes.
Joanne?
yes,
Okay. Let me get that over to you, Dave.
Some towns are doing DocuSign now, by the way, for
Um,
your edification.
But you still need a, can I keep this?
You can, yeah. No, they're doing it on the orders. Just if you were interested.
I'm avoiding doing
I,
EDEP as long as possible because we still need to print out a page.
no, I understand. Yeah, I understand. Yeah.
Thank you. So I'll still have to get theirs as well and I will.
Yep.
reach out. That's fine. Okay, so that was number 5. Mr. Andrews, will you please read number 6?
Okay, number 6. NOI file number pending, it says. Continued 280 State Road for the construction of a commercial building for an auto repair shop and paved parking area. The application is a response to the enforcement order certified by the commission by proposing the removal of approximately 1,830 square feet of pavement and the submission of a new stormwater management and landscape plan.
Can I get a motion to reopen this public hearing, please?
So moved.
So moved.
I got a motion by Amanda. Is it seconded by Dave?
I'll second it.
Okay, very good. How do we vote to reopen the public hearing? Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
yes,
Okay, very good. We are reopened. Okay, so since the last meeting, Mass DEP did provide comments. Again, I think maybe I'll read them and then you want to respond again.
That's fine.
Oh, I was over there looking at the other.
Okay, so the commission should refrain from issuing the order of conditions until the COC for DEP file number 3040378 is issued. Mass DEP recommends that any restoration work and plans in response to a violation should be addressed through the enforcement order. Please see the enforcement manual, page 7-2 and pages 8-4 to 8-5. The stormwater basin appears to be designed to provide infiltration to meet standard 3. The MA stormwater standards require infiltration BMPs be a minimum distance of 50 feet from any jurisdictional water or wetland. See V1, Chapter 1, page 8 of the Mass Stormwater Handbook. Site redesign may be required to accommodate relocation of any infiltrating stormwater management BMPs. Test pits are required at the location of any infiltration BMP to verify seasonal high groundwater and soil type. Please provide soil logs and confirm the depth is at least 2 feet to seasonal high groundwater and/or bedrock. Please provide documentation there is adequate groundwater separation for any infiltrating stormwater BMPs. Adequate pretreatment is required for an infiltrating BMP to achieve the listed credit percentage of TSS removal. See V1, Chapter 1, page 11. Please revise TSS worksheet as credit appears to have been taken for the pretreatment itself in addition to 80% for the infiltration basins that can only be credited for with pretreatment. See V2, Chapter 2, page 88. Where is the pretreatment for the infiltrating trench? And then they provided comments from DEP file number 0378, which is their open one. And then said the commission should refrain from, oh, that was to that one. Okay. So I just read the
New ones.
new comments. And then they provided the old ones. Do you want to respond to any of that?
Well,
or-
I guess, I'll say this first, or ask this first. Well, I'll say ask this first. I'm not sure if it's going to be a question or a comment or both. It sounds to, I was talking with the applicant today. I know there's been some discussion, between the applicant and the town on this, I think late last week. So I guess I was under the impression that the commission may want to continue this matter. And if that's the case, so it seems to me that, you folks are going to rely on DEP. And so we issued you a response letter on Friday, which you probably didn't get
We
until
got
today.
This,
Yeah.
we got this morning and I
Right.
did email it to all of
Right.
them. Yes.
So in understanding that that's not fair, and you're probably going to not take my word for it, and you guys can all correct me if I'm wrong, that you're really going to be looking for DEP to opine on our responses. What we'd like to do is just, instead of going through them chapter and verse tonight, unless you have something that you want to talk specifically about, that we'll just go back and work this through with DEP, and try to get a resolution to the matter, or not. I mean, perhaps we won't get resolution to the matter, but we hope to. And that's a suggestion, that we go through. We have provided you responses that you can read.
Yep.
I guess I'll just say, so that's our proposal this evening. If it pleases the commission, that we would like to, engage, at least attempt to engage with DEP to get, sign off on these things. I guess I will say, and we'll talk again, this will be part of the conversation we'll have with DEP, but I've been doing this for 25 years. I just don't know where it says anywhere in the regulations that you can't have 2 open orders of conditions at once. I looked, I can't find it, and it happens all the time. If this was a situation, and I get that we're not here, I think I said this the last time I was before you. If this was a situation where the work hadn't been done, we had an order of conditions that you folks approved and the work wasn't done, and the applicant had decided under the appropriate procedure to come before you to modify what they were proposing, that they wanted to do something different. They changed their mind. They wanted to do something different. There'd be 2 avenues that we'd have available to the applicant. One is to request an amendment to the order of conditions that you had issued. if it rose to the level outside of what you could approve as an amended order of conditions, the other remedy that you can do is to file a new notice of intent, which is what we did, because we felt that clearly the work that had been done seemed to be outside of the realm of an amended order of conditions. I understand that there is a enforcement order here in the mix, but I think that, and just to back up, if that had been the case and they had decided to do something after they had an approved order of conditions, there's nobody that would close out an order of conditions before they filed for and got a new one. So there's no applicant that would do that. And there's no consultant that would ever advise that, because you'd be at risk. You'd be essentially putting yourself at risk. And I just don't see any place in the regulations that says you can't do it. Be that as it may, I'm not asking you to agree or disagree. We'll go back to DEP and try to resolve that issue.
So.
But I did want to say that.
Well,
at
thank
least.
you, Greg. And, you know, we've all been in this process for a long time. Yourself and your applicant have requested continuances to get the Mass DEP comments. The discussion at the last meeting was how the comments were really going to align with the new project and support, and instead their comments were essentially site redesign and not so much in the applicant's favor. And
I just for the record, I don't see it that way at all. We believe they're all resolvable, but I just want to say for the record.
so there's an enforcement order on the site. There's an open order of conditions on the site.
Mhm.
And Mass DEP is our governing authority to which we report to. Every decision that this commission makes goes to Mass DEP for review and can be appealed by
Understood.
them.
Yep, understood.
So if we make the wrong decision, it goes to them. They are, however, not the appealing authority for an enforcement order. It would be Superior Court. And after my research and discussions with Mass DEP, the enforcement order is past 60 days, the applicant can appeal to Superior Court. So at this point, the only way out of this enforcement order is through it, not around it. The commission will not be issuing another order of conditions on the site until the first one is satisfied. And that includes the enforcement order being resolved.
Where do you, if you could just provide me, you don't have to tonight, but if you could provide me where it says what basis you have for that. Great. looking for it.
So also if we reject the newest NOI, that gives you a mechanism to appeal that to DEP, so you have an official channel to start conversations with or continue conversations with them.
I wouldn't do that.
No?
I would refrain from issuing an order of conditions. Refrain and so that I would advise you refrain so that they satisfy the enforcement order and go for a COC for the original and close out the file. That way it keeps this one open and they can come back to it after they satisfy the original order of conditions and get through the enforcement order.
Gives us the ability to come back to that one
If it gets rejected, then they have to go to Mass DEP for the rejection of this, and they are not the appealant authority for the enforcement. order. That is still in place. I would advise a refrain from a issuing of an order of conditions until the COC for 304 or 378 is issued, whereby the enforcement order is satisfied. Meaning they have to satisfy the enforcement order and get a COC on the original plans first, but it doesn't close this out.
But I guess I'm wearing my heart on the sleeve here a little bit. And I think I told you this 2 months ago when we opened this. The applicant is seeking to work with the commission to satisfy the enforcement order. We are seeking to try and get some, I'll call it a compromise here, but I guess we're trying to see if there's something that the commission can get behind that doesn't require us to go back to the originally approved plan.
They can't issue an order of
You
conditions.
can, we do it all the time. We negotiate enforcement orders all the
Greg,
time.
I respect you, but I want a list of these communities that you've gotten
We
order of
do, it happens
conditions through
all
on
the
other-
time.
because it's never happened here.
Well-
And Mass DEP is their governing authority and they're not gonna.
Well,
start
I
issuing
want to have a
order of
conversation with
conditions.
Mass DEP. it happens all the time. We do it all the time. Because sometimes it doesn't
But-
make sense
But
to go
maybe
through
they
and
do
do it.
with an open order of conditions, but not an.
But there is an
enforcement
open order condition, so
There
you
is,
have
but there's an
multiple.
enforcement order on it as well.
I understand, but we've responded to enforcement orders in the past where we've reached a compromise with the board. And I don't want to get into a pissing contest about it tonight. I want to tell you that we'll go back and try to resolve with DEP. I don't know if we'll be able to.
The
But I'd like to
enforcement
try.
order Issued by this board specifically states that no further permitting shall occur by this board. And by issuing an order of conditions, that would be violating their own enforcement order that they issued that says they weren't going to issue any further permitting to the site. They can't issue another permit to this site until the original is satisfied.
So what we can do is continue this hearing for another month
Why?
so that they have a chance to go talk to DEP.
DEP is not the appealant authority for your enforcement
I
order.
understand that.
This is a tough
I'm
one.
not sure, Amanda, what that's accomplishing. They wanted a continuation to get here another month to get the comments. They got the comments. The comments said the commission should refrain from issuing the order of conditions until the COC for DEP file number 304378 is issued. They are our governing authority. Do we not follow their lead?
Just a quick question, and this could be completely off topic again. I don't.
Name and address.
Katie LaGrange, 280 Soul, 280 State Road.
Thank you.
Thank you, sorry. To semi go back to the one that we were talking about before, where they had, this is the other NOI from the time before this, where they had a map that was wrong. I'm not saying that Mass DEP is wrong, but if for whatever reason in discussions between Greg and Mass DEP, they could come back, we could come back with our tail between our legs and say, you guys are right, which might happen.
Might.
But we could also go to them and say, here's a couple of things that says that we may be able to move forward in this direction. Would you guys be willing to continue for a month for us to possibly talk it out through Mass DEP, kind of like Amanda was saying? Again, we may come back with our tail between our legs, but it may also help us open that conversation with Mass DEP. I mean, I don't know.
Well, you either continue it or you act on it. I thought you just advised them not to act on it.
They would refrain from issuing an order of condition and direct you to satisfy the enforcement order, which would mean following the original plans and coming with a COC and an as-built for the original plans to close out the first file.
But
but
we are in a hearing
have a
with
file
an
here.
NOI that has a number from DEP.
That says to refrain from issuing the order of conditions until a COC for the original file number is issued.
And
They
what
don't-
motion would you like me to make to do that?
To refrain from issuing an order of conditions for this application until the COC for 3040378 is issued, whereby the enforcement order has been satisfied.
And then read the next sentence.
What's the next sentence?
To refrain from closing the hearing. So in
Oh,
order to do
hearing
that,
will-
we would
yeah.
have to continue it.
The hearing will not be closed, but it'll be removed from the agenda until new material is received.
Okay, that's fine.
Okay, that's fine.
I think we're talking semantic. I'm fine with that. The applicant's fine with that. Not that it matters, but just in case you can make whatever motion you want, but the applicant finds that language
We make a
acceptable.
motion?
You can.
Don't make a motion to refrain.
From issuing the order of conditions for this
Yes.
until the COC for the original is issued through by the enforcement order is satisfied.
Yes.
Do I have a second?
I'll second.
And adding that, or do you want a second motion for continuing? I was just going to say the hearing's not closed, but it's going to be removed from the agenda until new materials received. Is that sufficient or you want a second motion, Amanda, for a continuation? I think it's all in one. I think it's covered.
I honestly don't think a motion to refrain from something is legally allowed, but if the applicant is okay with whatever language we're using, then
As long as we keep the hearing open, we're okay with it.
yeah.
We're refraining from issuing an order of conditions. The hearing will not be closed, but I'm going to remove it from the agenda until new information is received. And the enforcement order and the original plans need to be satisfied. Any further discussion? Hearing none on that motion, how do you vote, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
Yes.
There you go.
All right, thanks, everybody. Appreciate it. Happy holidays. I'll see you. Which I probably
Luck.
won't.
See you next year.
See you next year.
It did that way, but yeah.
Yeah.
Mr. Andrews
Tom,
and Dave,
watch us on.
get all that back.
Thank you very
Bye,
much.
Katie.
We'll be in touch.
Yes, that's fine.
Right. That's Amanda's shul, yeah.
Thank you.
Okay. We ready?
I'm ready on number 7.
Number 7, NOI, no file, pending continued. 66 Rainbow Drive at Templeton Fish and Gun Club for the construction of a 20 by 20 foot deck within the 50-foot buffer zone of a wetland known as Partridgeville Pond.
Can I get a motion to reopen this public hearing?
So moved.
Second,
How do you vote to reopen? Amanda,
Aye.
Dave,
aye.
George, and Joanne?
Yes.
Good, 7:36. There's no notes, no further information, no new information, no file number, no representation present.
Make a motion, we hold next month.
Second,
On a motion to continue, how do you vote, Amanda?
Aye.
Dave,
aye.
George,
Yeah,
Joanne?
Yes.
Very good.
okay.
Number 8.
Number 8. NOI 304
None.
0392.
Oh, my agent updates. Number 8 is agent updates. NOI 304-0392, which was 1200 Patriots Road for the proposed U-Haul storage buildings. They withdrew their application. I believe I informed you all via email, but notifying the public.
Do we need to accept their withdrawal without prejudice?
Is that a thing? That sounds good to me.
Sure.
Accept. Thanks, Joanne. I like that. Conservation meetings in 2025, Dave and George. I just printed out the meeting schedule for 2025. I will give it to you, Amanda and Joanne, when I see you in person, when you come in
Thank
to
you.
sign all this stuff.
Yep.
Next, Mass DEP has appealed the negative determination for 80 and 81 Rainbow Drive for the retaining wall, and they have set up a site walk
January 11th,
for
right?
January at the site. I provided you all via email their letter. They talked about the work being in bordering land subject to flooding and
Yeah.
even though the drawdown, so they wanted to exercise their right to an appeal, and they're gonna go do that. Next, critical drought conditions. Just so you guys know, Massachusetts Central Region is still in a level 3 critical drought. This means that observations of no flow for any incoming RDAs, ORADs, NOIs may not be used to change the status of a river within the riverfront until level 0 is received again. Update for you all, Wetlands Protection Fund expenditure. At the last meeting, I came to you all with the proposal to get the Jersey barriers.
Yep.
And for the Otter River
Cool.
pool Cardiac Dam, yep. And the next day I went to the select board meeting and got their support as well. So at this point, I'm working with the DPS director on acquiring the concrete blocks, and then I will pay that out of the Wetlands Protection Fund and report back to you all.
Thank you.
Welcome. On that line, update from Joanne and I that the Otter River Pool MVP grant was submitted by the town grant writer, and she's keeping Joanne and I informed of steps along the way. Again, it's a very competitive grant, and we're not considered, hazard, but we're not giving up, and we're gonna continue to seek funding as much as we can. Anything to add, Joanne?
No, nothing new.
Okay. With that, we have number 9, chair or member comments. Mr. Andrews, anything?
I have nothing. Everything's been said, we've said.
Dave, any comments?
No comments.
Amanda, any comments?
Nope.
Joanne, anything extra?
No,
Very good. Our next meeting is Monday, February 13th, 2025 at 6:30 PM. Can I get a motion to adjourn?
I'll make a motion to adjourn.
Can I get a second?
Seconded.
By Amanda. I have to still take a roll call vote. And how do you vote on a motion to adjourn, Amanda?
Aye.
Dave?
Aye.
George?
Aye.
Joanne?
yes.